Good morning, Your Honors. My name is Dan Citron. I represent the plaintiff, Nikisha Johnson, and with me is Lisa Gay Smith, attorney, who probably spent 20% of her time with my law firm working on this case, actually. So I'm going to defer to the court as to what issues, if any, concern you, since there's 5 issues that we believe are all frivolous in light of waivers, objections, or just plain all-out frivolous, if there's any questions.
Well, one argument that's made by appellant is that he was effectively deprived of effective cross-examination of the plaintiff about her prior medical records. And in reviewing the cross-examination, I noted where at one point you made an objection to, he was asking about her prior medical records and, basically showing her records. Didn't you complain about this, have this complaint on this date? When you objected, saying that he cannot impeach her with something she did not write or sign or she did not author. And then it looks like a very lengthy, with the jury, outside the jury's presence, a very lengthy argument went on. Were they precluded from questioning her about her prior medical records?
Absolutely not precluded. What I was arguing was that he was holding up records that somebody else wrote and said, isn't it true, and waving it around, and that's improper.
Her medical doctor's records, though, correct?
That is correct. Now, that could have been used to ask her if she read. You can't impeach somebody with something they didn't write. They could have asked her, isn't it true that you were allergic to bacon? Isn't it true that you had sickle cell anemia? My argument was that they can't impeach her and show her doctor's records that she didn't write. They can ask her the question and then put the records into evidence and then have their IME, Dr. Routman, testify about them, but they cannot impeach her with something that she did not say, write herself, or say.
Well, the question was, and you went down there August 29th of 08 and went in there complaining of left flat pain that started yesterday, and you denied any trauma. I think that's a perfectly acceptable question to ask her on cross-examination from her medical records.
Okay, so that particular question may have been correct.
But that was the question you objected to.
No. Okay, and I was the trial counsel. I believe that papers were being waved around at that time. That was the issue there.
How do you respond to the argument that your comment that if the defendant does not take care of the plaintiff, she will end up on welfare, does not constitute fundamental error?
Yes, Your Honor. So basically, first of all, there was only 1 or 2 objections. There was no motions for mistrial. There was no request for curative instruction. So basically, under the analysis, a party could sit back there, not ask for a curative, not ask for a mistrial, and keep the appellate review process in their back pocket so they get 2 bites of the proverbial apple. Had he come in at the right time and objected.
How would you suggest that a comment like that could be cured?
A comment like that could be cured by stating specifically, ladies and gentlemen of the jury, it is inappropriate for you to consider the wealth or lack of wealth of the plaintiff or the defendant, and that you should decide this case on the instructions that I'm going to instruct you on. So I think it's a fairly simple curative instruction. But to answer your question, under Murphy, for them to preserve this error, number 1, it has to show that the comments were improper. And then again, that one, I don't even know if that one was.
You can see that meets that problem.
Right, and I don't know if that one was objected to, Your Honor, but it certainly was not. They didn't move for a mistrial on it. This did not result in a miscarriage of justice. I'm sitting there arguing. Sometimes you do get carried away. An objection comes in, and you stop, and you realize what you've said and what you've done, because we've been with these cases for 6-7 years in this particular case. But under Campiani, the Supreme Court case, Campiani says that error has been cured if there's no request or for curative instruction. So under Campiani, there's no error, because if they don't ask for that,
Yeah, unless there's fundamental error.
unless there's fundamental error. So, and you don't need to engage in the harmless error analysis, because there is no error without preserving it. So the error is waived. Now, this is it has to be incurable, and I wrote down, here's the curative instruction. Ladies and gentlemen, any reference to the wealth or lack thereof shall be ignored by you and not considered by you in determining the amount of the damages you award to Nikisha Johnson. But number 4, the fourth element that has to be met, all 4 elements need to be met, is that the argument so damaged the fairness of the trial that the public's interest in our system of justice requires a new trial. And the Supreme Court gave 3 things that felt into that criteria, and I believe it was race, religion, and there was one other.
It didn't limit it to those categories, though, did it?
Well, it didn't, but that's correct. It didn't. But this was not remotely pervasive. This was not some closing argument like, for example, under the Yardle case, this court wrote, Judge Warner writing with Connor and Levine, there were remarks that exploited the court's ruling on motion to eliminate. That didn't occur in this case. Improper comments regarding the financial disparity between the plaintiffs and the defendants in that case. Improper golden rule arguments, not in this case. Improper expressions of personal beliefs and experiences, and improper attacks on the defendants, defense counsel, and defense witnesses. And under Murphy, this court held that the defendants could not conclude that the court held they could not conclude that the trial court abused its discretion in denying the motion. They said, as Murphy noted, the trial court can review the remarks in the context of an entire trial far better than the appellate court. We defer to the trial court's evaluation, as no abuse of discretion has been shown. Appellants also failed to show that all the remarks were incurable, including the remarks about the financial disparity between the plaintiffs and the defendants. And also the court wrote that they were in fair reply. So, should some of these remarks have been made? No. Did the defendants have a near perfect trial? They did. This was close to a near perfect trial. So,
Can I ask you about something else, going back to the number of injuries or illnesses that your client apparently had encountered and were not disclosed to the side? Was there anything done prior to trial by the defense to, because we usually see either motions to dismiss for fraud prior to even get trial once defendant becomes aware of multiple things that have not been disclosed. Would anything like that happen here?
yes, there were 2 motions to dismiss for fraud that were denied by the trial court. But
Based on these same
based on these same things.
medical records?
But here's the only thing that this girl had. By the way, she had 17 epidurals or similar procedures following this accident. Before this, she never had a procedure, and she never in her life had any treatment to her low back, which was the whole case. So they're talking about sickle cell anemia, and they were talking about bacon in this case, that she never disclosed to them at the emergency room that she had bacon. She was in an accident in 2000. They had all these records. She was in an accident 3 years before. She fractured, and the records were in evidence. She fractured her pinky, and she had never had any back complaints. So this is just a whole creation. What does sickle cell anemia have to do with a low back complaint? And even their IME doctor, Dr. Routman, who you may be familiar with, I went through the whole litany of the case with Dr. Routman. Dr. Routman helped prove my case. I said, Dr. Routman, isn't it true you didn't find in the entire record any complaints of low back pain before this incident? Yes, that's true. And she never got any treatment before this in her entire life for 26 years, whatever it was before. And so she testified on the stand. I think she said one time when she was pregnant, she might have had a back pain or something like that. So it's because she didn't disclose that she had sickle cell anemia, which Dr. Routman agreed that in reviewing the entire chart, there was no evidence that she had sickle cell anemia. She had plain anemia 10 years before she filled out a questionnaire. It said, do you have all these conditions? And I think she's a high school graduate, and so she saw the word anemia. She wrote that down. What does that have to do with a low back injury that this lady sustained in this case? So, and a lot of the facts that they put in here.
Now, my purpose for asking you the question, though, about whether anything had occurred prior to trial was to understand, because the argument made by the appellant is, look, we found these things, but we didn't have enough time to really go into them. But you're telling me that, in fact, there were 2 motions to dismiss on the same grounds based on these medical records prior to trial. So obviously the defendant had the records in sufficient time to do something with them.
Absolutely, they've had. I mean, they've had them. They had them for probably more than a year, at least before trial. And as Judge Kaiser wrote in that opinion, that JVC, the ultimate question is whether reasonable minds could differ as to the propriety of the decision. And in our position, we think that reasonable minds could not differ here, and that there absolutely is no basis for motion to dismiss for fraud. If you read this, and they're complaining about her not disclosing about bacon, and you know, even when she was pregnant, she went to the hospital 3 weeks before, and she had some dizziness. All these things were in the medical records, and there was nothing that was not disclosed. For example, and then they took things out of context many times, and they said there were times when she went to the doctor after the accident that she didn't complain about low back problems, for example. But there were times that she did. You don't go to the OBGYN every time when you're seeing 7 different doctors at different times, from a chiropractor to an orthopedist, and say, oh, and I have back pain today also. You're going there because you got a baby. You want to make sure that the baby's okay. And so the doctor is not concerned with back pain. The doctor is concerned as to whether there's still a breathing heart inside the woman. So these things that they came up with, and this list, you know, there would be an argument here if, for example, she had had a history, as in all these cases that dismissed upon with fraud, where she had had a history of the same problem before, treated for it, and didn't disclose it. But that's not the issue here. And the one instance that he says that she had had chiropractic before, what had happened was she saw a chiropractor about 1.5 years after this particular incident. And so one of the questions was, have you ever had chiropractic before? And she said yes, before the 1.5 years, in other words, 1.5 years after the accident. She confused chiropractic from the physical therapy that she had after this accident. So, you know, just because she doesn't know the terminology, just because she's not medically intelligent, just because she doesn't go to a doctor every time and say the same thing over and over again, you know, you're going to a new chiropractor. You're not going to say necessarily, I have anemia. I mean, maybe if you're going for the epidurals, you're going to say it. But I just think that this whole list here, and you know, it's nicely written, it's nicely worded, but it doesn't remotely border upon a scheme or anything of that nature to defraud any court.
Let me ask you one other question with regard to the trial court's handling of the motion in limine and the Daubert issue. I know the pretrial order required the motion to be filed 30 days in advance. It was not. But the judge did go ahead and consider it. Does that eliminate the untimeliness issue of the motion?
He didn't consider it. He actually, he ended up doing some kind of Daubert type thing where he decimated both of my experts' testimony. And he limited their testimony there to George Zimmerman, the architect, could only testify as to standards. He never gave an opinion on negligence or causation. And my second hospitality expert decimated he said, no, you didn't examine that exact step, so you can't testify as to what you found on the date you flew in from Colorado to do the testing. So he threw out that entire, which was totally erroneous. And so he was limited to testifying that there should have been a mat in the ice machine area, or like a grating so that that somebody would not slip. And and then on top of that, there were admissions that make that whole argument silly, because the defense witness testified that the floor was slippery when wet, and the defendant attorney came up there and said, this floor, we would be disingenuous in saying to the jury in his opening, we would be disingenuous in saying that these tile floors are not slippery when wet. So, and I put about 6 reasons down there why the Daubert issue is not relevant, but I just wrote, and I'll finish up with this. Parties failing to follow pretrial or other orders of the court interfere with the orderly administration of the judicial system. No valid excuse for failure to follow the pretrial order was even offered. Such violations of court orders should not be countenanced by reversing trial judges for properly administering their dockets pursuant to their orders. To do otherwise would render their orders and their positions in society meaningless. Your Honor, thank you very much, and we ask that you affirm.
Thank you, Citron.